Laura.
No problem.
So my name is Lauren Rousseau. I'm the president of this fan chapter, which is Northwest Wayne Fan. My sidekick here, who is helping manage this meeting, who's been talking a little bit, is Dara Cockrum, and she is the vice president of our fan chapter. So this is our monthly public forum, as you hopefully all know, and it's our May forum. I'm going to briefly share some PowerPoint slides. I've started doing this with all of the online meetings because there may be some information that you want to write down. You know, the downside of our online meetings is that we aren't really able to hand out flyers that you can take with you that has information you might need. So I do the PowerPoint slides instead. So let me just remember how to share here for a second. All right. And then we will go to there. All right, so as I said, this is our May public forum, and I think that most of you, possibly all of you, are familiar with Families Against Narcotics. In case you aren't, I'm going to give you just a little bit of information about us. So Families Against Narcotics is an organization that started in 2008 with a single fan chapter in Macomb County. It's grown to the point where it has 20 chapters in Michigan at this point, and ours, the Northwest Wayne chapter, started in April of 2017. So our mission, you can see on this PowerPoint slide, is to provide education, resources, and support to families and individuals impacted by addiction. Families Against Narcotics has many different programs that serves that mission. One of the primary ones is what you're attending right now, right? We have every chapter has monthly public forums that are basically educational in nature. We have different speakers come in to speak about different issues related to addiction, typically encourage question and answer periods at some point during that meeting as well, so you can get some information that you may need with whatever situation you're dealing with from an addiction perspective. Our monthly public forums are the first Monday of every month. We are, as you know, they're on Zoom right now. Normally they're in Canton. We normally meet in person at Summit in the Park in Canton. But because of the COVID epidemic, we have been having the meetings online on Zoom, and it's also on Facebook Live. Also, as you can see on this PowerPoint slide, all of our public forums are recorded and are placed on our YouTube channel. So if you are interested after this meeting in exploring what other topics and other speakers that we've had in the past, you can go to our YouTube channel, NW Wayne Fan, and you can take a look, see what's there, and maybe explore some of the other forums that we've had in the past. Our fan chapter also serves fans' mission with 2 support groups. So we have a grief support group and a Stronger Together family and friends support group. The grief support group is specifically for individuals who've lost a loved one as a result of addiction. It is currently meeting in person at the PCL&O Club in Canton. You see the address there on the PowerPoint slide. The meetings are the first and third Tuesday of every month from 7 to 8:30 p.m. Masks are required and social distancing is in effect to ensure the safety of everyone who attends. Our family and friends support group is meeting on Zoom. That's meeting the second and fourth Tuesday of every month from 6:30 to 7:30 p.m. The meeting ID and password you can see on the PowerPoint slide, and it's the same meeting ID and password that was used to enter into this Zoom meeting tonight. The family and friends support group is for people who have a loved one who is struggling with addiction and who are looking for support from other people who've dealt with the same situation. Another program that our fan chapter supports and is basically going forward with is the Hope Not Handcuffs program. So I would bet that probably most of the people who are in the meeting today are familiar with our Hope Not Handcuffs program. It's been in the news quite a bit, and most of the fan chapters have this program in effect. We just launched the program with 2 police departments in our Northwest Wayne area, which is the City of Wayne and the Garden City Police Departments. So the idea here is, if you are someone who's struggling with addiction and you want help, you can walk into a participating police department and say that you want help through the Hope Not Handcuffs program, and no question asked, that police officer who's on duty will contact our angel coordinator, who will then contact a trained angel, we call them angels, that will get to you to the police station within 20-30 minutes and then work with you to help you access treatment right then and there. So we provide angel training, right? If you are interested in learning more about this program and maybe becoming an angel yourself, you can go on the Families Against Narcotics website /Hope Not Handcuffs and see what trainings are being offered. So we've been having trainings about twice a month. I don't think they're already scheduled right now, but they will be soon. So if you're interested in participating in this program, again, the website and the address for the program is there on the PowerPoint slide. You can go and check it out and get a little more information. We just recently passed 5,000 people who we have helped into access treatment since this program launched at FAN overall. And it launched in February 2017. So in February 2017 is when it first launched, and it's been over 5,000 people at this point that have been helped to access treatment through this program. And then last, I just wanted to put our address for our Facebook page. Our Facebook page will provide you with information about any upcoming events. Our public forums are posted there as an event, and you'll get information then about what the topic is for the upcoming public forum. Our family and friends support group and our grief support group are also events for each meeting are posted on the Facebook page. So if you're not remembering how you can access a meeting, you can go on the Facebook page and you get that information. We also post all kinds of articles that might be of interest to our members. So if you are interested, if you're interested in any of that information, you might want to jump on our Facebook page, like our Facebook page, and then you'll be able to see that information. All right. Laura, do you hear that?
I do hear that. It's like somebody's got the meeting going on in the background.
Yeah, somebody needs to mute something.
Right. They need to mute.
Yeah. All right. So
there we go. Okay.
Thank you.
Thanks.
All right. So our public forum today, the topic is legal options for individuals and families dealing with addiction. And we have 4 speakers today. We are delighted to have to speak with us on this topic. You can see their names on this PowerPoint slide. Judge Laura Mack, State Court Administrator Emeritus Milton Mack, former Judge and Attorney Jodi Switalski, and Jaime White, the Director of Clinical Development and Crisis Services for Hegira Health. I am going to give a little bit more detail regarding each one of our speakers, a little bit of a bio right now, to just help you understand a little bit of their background. And then I'm going to turn it over to our first speaker, who will be Judge Laura Mack. Each speaker will speak for about 15 minutes or so, and then there'll be some time at the end for sort of a Q&A. So let me do that. Sarah, are you having a hard time finding that person?
I am. I'm sorry.
Could
everybody mute?
734 number, because every time she talks, it's like their number in the black screen is popping up. So it's a 734-444 number. I don't know who that is, but
I don't know. It looks like it got taken care of. Thank you.
Okay, great. Thanks. Thanks so much, Kelly. All right, so our first speaker tonight is going to be Judge Laura Mack. Judge Mack recently retired as district judge for the 29th District Court in Wayne. She was chief judge of that court for 16 years. She's currently a director for the Michigan Association of Treatment Court Professionals, and she's also a director on our board, the Northwest Wayne chapter of Families Against Narcotics. She is the president of the Rotary Club of Wayne. She serves on the State Court Administrative Office Mental Health Advisory Committee, the Governor's Mental Health Diversion Council and Competent Stand Trial Work Group, and the Wayne County Jail Diversion Committee, and the Wayne County Jail Diversion Committee. Judge Mack continues to preside, along with Judge Brita O'Leary, over the Western Wayne County Regional Behavioral Treatment Court, which originated in October 2013. So that's Judge Mack. Our second speaker, as I mentioned, is State Court Administrator Emeritus Milton Mack. Judge Mack served as state court administrator from 2015 to 2020. He previously served as a judge for the Wayne County Probate Court from 1990 to 2015 and as chief judge from 1998 to 2015. He served as co-chair of the National Initiative Advisory Committee to improve the justice system response to those with mental illness, and he currently serves on the National Task Force to examine state courts' response to mental illness. Judge Mack currently serves as the chair of Governor Whitmer's Mental Health Diversion Council. He also served on Governor Granholm's Michigan Mental Health Commission in 2004, the Michigan Partners in Crisis Public Policy Committee, and the Michigan Supreme Court Guardianship Task Force. Judge Mack has authored important policy papers and articles on the subject of mental illness in the criminal justice system. In 2017, he received the Snyder Koch Award from the Mental Health Association of Michigan, was named Judge of the Year by the Michigan Guardianship Association, and Advocate of the Year by NAMI Michigan. Our third speaker will be Jodi Switalski. Jodi served as a Macomb County prosecutor for 5 years with an impeccable trial record before serving as magistrate in the 45th District Court, then being appointed to the bench by the governor of the state of Michigan. She served as one of 2 judges on the 51st District Court in Waterford from late 2010 to early 2016. Jodi is a nationally recognized speaker on the subject of addiction and the law, and she recently returned to the courtroom, focusing her law practice on criminal and family law. Through her firm, Switalski Law Consulting, she provides risk mitigation services as it relates to workplace and medical dental consulting with respect to the opioid and controlled substance epidemic. She fluently understands substance abuse, addiction, and dependency, and has become a zealous and unique advocate for individuals as they navigate.
Lauren, could you oh my God. Hold on.
I'm not muted. Did you mute me somehow?
I somehow did. I'm so sorry. I was trying to mute somebody else.
When did you cut me off?
I think when you were talking about, were you just introducing Jodi?
Yes.
Yeah, I think, I don't know exactly where. Why don't we start over to make sure everybody heard everything about her credentials?
All right. So starting from the top, with respect to our third wonderful speaker, Jodi Switalski. Jodi served as a Macomb County prosecutor for 5 years with an impeccable trial record before serving as magistrate in the 45th District Court and then being appointed to the bench by the governor of the state of Michigan. She served as one of 2 judges at 51st District Court in Waterford from late 2010 to early 2016. She is a nationally recognized speaker on the subject of addiction and the law, and she's recently returned to the courtroom, focusing her law practice on criminal and family law. Through her firm, Switalski Law Consulting, she provides risk mitigation services as it relates to workplace and medical dental consulting with respect to opioid and controlled substance epidemic. She fluently understands substance abuse addiction and dependency and has become a zealous and unique advocate for individuals as they navigate their recovery and seek remedies to legal situations that impede their progress. And our final speaker, our fourth speaker, is Jaime White. Jaime White's a leading advocate for crisis service development with a particular interest for integration of community behavioral health services and law enforcement. She has almost 20 years of experience in the behavioral health field. She earned her Bachelor of Arts degree in psychology from the University of Michigan and her Master of Education in Human Development Counseling from Vanderbilt University. In 2016, she completed a certificate in integrated behavioral health and primary care from the University of Michigan and completed the Leadership Detroit training and program in 2020. Jaime has been on the staff with Hegira Health since 2008, formerly as the Administrator of Children's Services and currently as the Director of Clinical Development and Crisis Services. Jaime has held her current position since 2016 and leads Hegira's Trauma-Informed Care Initiative, Hospital Admission Prevention Team, and Critical Incident Stress Management Team. Jaime is also the project lead of Hegira's First Responder Wellness Initiative and a Detroit Wayne CIT trainer. All right, those are our 4 speakers. I'm now going to unshare the PowerPoint slide and turn this over to our first speaker, Judge Laura Mack.
Well, thank you, Lauren. Welcome, everyone. It's good to see all of you. That was a wonderful introduction. I'm going to talk to you about some pretty boring things. I'm going to actually straddle the civil and the criminal side of planning for a loved one that has an addiction or a substance use disorder. You know, I was in a unique position. I was actually a victim of 2 crimes that were related to substance use disorder in my personal life, and as well as being a district judge for 16 years. Substance use disorder is just something that comes up every day in the criminal justice system. So I learned through my personal life that planning actually works. It can help. And so I'm going to share with you some of my insights. Also, I used to be a tax lawyer before I became a judge. And that's what I did for a living, was did planning for people, created documents, trusts, wills, patient advocate designations, durable powers of attorney. And so some of those documents can help you, I think, deal with a loved one's substance use disorder. It's a disability. And this is planning for disability, basically. So I am going to share my screen because I do have a PowerPoint. Hopefully I can get it to come up. There we go. Okay. Okay. So, and I'm going to go through this so quickly because we really don't have a lot of time. So anybody who's interested in seeing my slides, because I do have documents embedded in the slides, just ask Lauren and she'll be happy to share the PowerPoint with you. So I'm first going to just talk briefly about some documents that you might want to consider. Obviously, your loved one has to consent to sign these documents. So you'd have to get them at a point where they're receptive, they're willing, they're in remission, their problem isn't a problem right now. Or for, you know, for leverage, if you're helping them do something, say, I'm willing to help you, but you've got to help me and sign these documents for me. So that's, you know, how I would approach it. First is a durable power of attorney, which everyone should have, actually. Patient advocate designation, consent to share health information, and a HIPAA authorization. Durable power of attorney is a document that enables you to act on your loved one's behalf, either immediately or upon a trigger event, like incapacity. And you can define incapacity in any way you want in the document. It can be a person that decides it. It can be more than one person. It can be a doctor. It can be a lawyer. It can be an addiction doctor. You can define what you mean by incapacity. And then once that event is triggered, then the agent can act on behalf of the principal and be able to sign documents for them, name them as a guardian in case that kind of intervention is needed. So your loved one can appoint someone in advance to take over if need be, if they're in a really bad way. And I know not everybody's going to agree with this, but it's a tool that can be used and it can be used very effectively. I'm going to get into more detail. The other document that we're talking about right now is the patient advocate designation. That's a medical power of attorney. Make all medical and mental health decisions if you're in a coma. And, you know, if you have a loved one that's has a substance use disorder, you should really get them to sign this because they could overdose and be in a coma. And then you could act on their behalf. Of course, they have to want you to act on their behalf. But I'm just going to show you some examples of what I'm talking about, the durable power of attorney. This document's gives broad powers to the attorney, in fact, or the agent. I've added in red because it's easiest if you make it effective immediately. Like the ideal situation is you go to your son or daughter when they're in remission, they're not in active addiction, and say, I'd really like you to sign this for me. I'll just keep it in a file and I won't use it only if it becomes necessary. If they trust you, maybe they'll sign it. And then when the need arises, you don't have to trigger, you don't have to prove anything. You just immediately can step in and handle their affairs for them. The other alternative is to make it effective upon a triggering event. And I've described something, I just drafted this language, but you know, your attorney could draft something specific to you as to what the triggering event is. And these are just, you know, the basic kinds of powers. I didn't include all of it because it's very lengthy. But the interesting ones, I think, and useful ones are guardian. You can appoint your agent or someone else to be your guardian in the event you need one. And in fact, in Milt, my husband is going to talk to you about guardianships. But you can avoid having a guardian appointed for you if you have this document. And then medical, mental health, and substance use disorder treatment. You know, putting this in your document could make it easier for your agent or for you to get treatment for your loved one. So that's just an example. You can't really use this as a form. This is only general information. It's not legal advice. Okay, I can't possibly know your situation. Every situation is different. So you would have to consult with an attorney, I think, before attempting to use any of these documents. The patient advocate designation, this is a form that's found on the Michigan Department of Health and Human Services website. You can fill that in by yourself. And I would strongly recommend that even if your loved one doesn't want to sign a durable power of attorney, at least have them sign this. It states their wishes. There's actually a power on the next page for mental health treatment. So they could consent to outpatient treatment, maybe, psychotropic medication, but not anything else. This can be very useful for somebody who has a mental illness and who is in remission and is not, you know, exhibiting terrible symptoms, but they know that they might, you know, so they could sign this as a way of preparing. Consent to share health information in HIPAA. When I still am working with the mental health court, consent to share information is vital. You need every participant to sign this so that you can get information about their treatment from their other providers. And there's no reason why an individual couldn't use this consent also in order to make it easier to help your loved one get treatment. So I have included the form after this slide. And then the last one is the HIPAA authorization. Created this while I was doing estate planning, and just after HIPAA passed, and I've actually used it. I used it with doctors' offices with my mother-in-law, and it's just a very broad authorization to share medical records. So here is the consent to share behavioral, came across the top there, behavioral health information. So this is the state sanctioned form, and it basically relates to behavioral health and substance use disorder information. So if you wanted to share, if your loved one wanted to share information about their treatment with you, they should sign this document and name you as the person to receive the information. So that's that. And then here's the HIPAA authorization that I mentioned before. It just basically says that you can give the information to my person without violating HIPAA. I waive HIPAA. I waive my privacy rights with respect to my medical treatment, so that this person can make appointments for you, things like that, communicate with the doctor. Whoops. I don't know what happened there. Did I do that? Okay, anyway, that's that. And then just briefly, you should think about how you own assets with your loved one. If you have a loved one with a substance use disorder, don't co-sign anything. Don't co-own a vehicle, because you could be liable if they get into an accident and injure someone. Consider purchasing life insurance on their life, especially if they have children, that kind of thing. These are things nobody wants to think about, but you really should if you have a loved one that's struggling with substance use disorder. If they're young, if they're under 26, consider removing them from your health insurance so they can qualify for Medicaid. You know, again, it's Medicaid is the best insurance that money can't buy, but it's really helpful for mental health treatment and also substance abuse treatment. It pays for more than private insurance does. So if you have money, if you have assets, it's not a good idea to name your addicted loved one as an outright beneficiary. You should consider a trust, a support trust, possibly, that gives them money as they need it. And you can always change it. You know, if your person goes into remission and is drug-free for, you know, a certain number of years, you can always go back and change your documents. But it just isn't a good idea if something happens to you that everything goes to your loved one, who may squander it and who may overdose. You don't know. Obviously, don't name them as attorney in fact or patient advocate for you, or have a backup. Criminal behavior. Okay, so they get arrested. What I was talking about before is mostly civil. Okay, once it becomes criminal, drug use and drug abuse leads to crime. And the most common crimes, you know, this is a very short list, but you know, these are the most obvious and the most common: illegal possession and or delivery, retail fraud, theft, breaking and entering, assault, domestic violence, operating while intoxicated, and then abuse and neglect of children, which is a huge area in and of itself. So what do you do when you're the victim? And that is another area that, you know, could be the topic of a whole public forum. But in my instance, I did press charges against the people who committed the crimes against me. In one case, it worked out well. My loved one got treatment for his substance use disorder, and he was clean for an entire year. Now, after the year was up, he went back to using it and ended up dying because of it. But I was happy that I did press charges because he did get the help he needed, and he wasn't able to minimize the fact that he had done this. But before you do that, you should know your rights as a victim. Know that once you become a victim, you really, the case is really out of your hands in a lot of ways. But things are better now than they were when I had the experience with my first husband. But victims do have more rights now than they did back then. So I'm just telling you where you could make a difference. So at arraignment, and this doesn't, you know, whether or not you're the victim, it doesn't matter. But, you know, at the charge where the person is taken into custody, they're arraigned before a judge. Judge sets a bond. Okay, purpose of that is to ensure they appear in court and to protect society, including your loved one. Judge can accept input from the victim and the loved one's family. Common conditions that we set at bond, pretrial release conditions. Okay, I'm going to let you go, but you're going to have to do these things while you're out on bond. And if you don't do them, you can go to jail. Drug testing, substance use disorder assessment, no contact with the victim, no going back to where it happened, tether, house arrest. Very helpful if you have someone in active addiction. You can ask the judge to order the loved one to be released only to your care and receives substance use disorder treatment as a condition of release. And again, you know, every circumstance is different. This is a very brief overview. If they behave well on bond, it can result in a better plea deal. Use fear of jail to motivate your loved one. 2, attend AA, a drug test, even if not court ordered to. Begin residential treatment. Look into medication-assisted treatment options. All of those are going to look good to the judge. Have the loved one evaluated for mental illness, for possible mental health court eligibility. And I'll talk very briefly about that in a moment. Ask the court-appointed attorney to advocate for admission to a drug court if available. So those are things that you can do. Sentencing options that can result in dismissal of the case. Holmes Youthful Trainee Act for people 17 to 24. Domestic violence first offense. Drug possession first offense. Delayed sentencing under 771.1. And mental health court completion, successful completion. You can get a dismissal. All of these are non-public except for the delayed sentencing, meaning that nobody knows except law enforcement that you have this conviction on your record. And then there is a dismissal at the end. Problem-solving courts reduce recidivism. They work. People that go through problem-solving courts are less likely to commit crimes in the future. Michigan has right now 137 approved treatment courts. So they run the gamut, you know, there's tons of different names, but most of them are drug courts, sobriety courts, mental health courts, and various variations on that. But if your loved one is adjudicated in a jurisdiction that doesn't have one, the case can probably be transferred to a court that does have a specialty court. And defense attorneys these days are really a lot better than they used to be because of the indigent defense reforms that were enacted a few years ago. Defense attorneys, court-appointed defense attorneys are really very good. And I'm sure Jodi Switalski will talk more about criminal defense. But your court-appointed attorney should be able to help you, with navigate these waters. And then legal disclaimer, as I said, I wouldn't be a good lawyer if I didn't do this. This is just general legal advice or general information, not legal advice. And you should contact an attorney for advice on your particular situation. And I did say here, probate attorneys, if you're interested in a guardianship, durable powers of attorney, that kind of thing, the Wayne County Probate Bar Association is a good resource. You can go to them and they can give you a good referral. Also, the State Bar Michigan Attorney Referral Service, Michigan Legal Help website is a very good website for people trying to navigate the legal system. And then Lakeshore Legal Aid is an excellent legal aid that I work with at the 29th District Court. And I'm always impressed really by them. They get back to people. They're good. They're well prepared. So I've been pleasantly surprised by their competence. So I think that's my presentation. Hopefully I didn't go over in time.
Judge Mack, thank you so much for that. What a lot of amazing information. That's a very dense presentation, kind of a survey of a lot of different things. I have a feeling that we're going to have to go back and look at that PowerPoint presentation and pull out different things and have whole forums dedicated to some of those topics. So as Judge Mack mentioned earlier, if you're interested in getting a copy of her presentation or the other presentations from the speakers today, you can send an email to our email address, nwwayne@familiesagainstnarcotics.org. At the end of the speakers and Q&A, I'm going to throw up another PowerPoint slide that will give you that address again so that you'll be able to write it down if you're interested in getting a copy of this presentation. But thank you so much, Judge Mack. Really appreciate that. All right, so now we have Judge Milton Mack. Turning it over to you. Except we need to unmute you. Dara, can you unmute him?
I'm unmuted. I'm unmuted.
Oh, there we go. Great, thank you.
Let's see. Whoops. Is it up? I can't hear anybody. Is it up?
Can you hear me?
Yeah, I hear you.
Yep, it is up, yes.
Okay, great. All right. Technology is wonderful and it works. So I'm going to talk to you about some of the court options that are potentially available when you're dealing with behavioral disorders like substance abuse and particularly dual diagnosis with mental illness and substance abuse. One of the interesting statutes out there that was passed in 2014 is a petition for involuntary treatment for substance use disorder. This law was passed in 2014 to basically put together a framework for ordering involuntary treatment for someone with a substance use disorder. It's modeled after the Marshman Act in Florida. Basically, you file a petition with the probate court. You allege that the person has a substance use disorder. You allege that they present an imminent threat of danger to self, family, or others, and that they can reasonably benefit from treatment. Now, then it gets tricky because you have to attach a certified statement of a health professional who has examined the person in the last 48 hours. So they have to, you get the statement from 48 hours before filing, which is pretty tough. If you don't have one, you can tell the court that the person refuses to be examined, and you can ask the court to order the person to appear for an examination, and the law enforcement will arrange for that. But then you also have to identify and have arranged for an examination as well as treatment for the person ahead of time and identified in your petition. You have to prove or show that the facility has agreed to treat this person and they've identified the estimated cost. And the petitioner has to guarantee to pay the cost of the examination, the attorney fees, and the cost of treatment. So it's a pretty substantial barrier to intervention. In fact, it's used so little that Scale has now developed a form for it this is a form from Ottawa County, which I'm not going to go through. You can look at it at your leisure if you wish. I'm going to move on to a discussion of how this law is not working. Basically, we did a survey of the probate judges in March of this year, and in 85% of our counties, there were no petitions filed. One county had more than 2, and they had 6. But the judges all cited numerous barriers to accessing the statute, because the statute could be very useful. It's useful in Florida, for example. But the judges identified what the big barriers were to using this statute. Number one was treatment cost, guaranteeing the cost of payment in advance. And of course, lack of awareness. Most people don't know about this law because it's so little used. People found the examination cost a barrier. Others were worried about the court costs you'd have to pay. And then trying to identify in advance who the provider would be was also a significant barrier. I will say this because I was involved in the drafting of this bill back in 2014, and these barriers were anticipated, but the sponsor wanted to get a bill on the books, and he was hoping that over time, the issues of cost and access would be addressed later on. And I do get a sense at this point that this might be the time to look at removing the barriers that are associated with this statute. I've been in touch with the CMH program in West Michigan, and they appear to want to do that. And we see more and more people looking at mental illness and substance abuse treatment together. And this might help us to remove those barriers. So if we can remove those barriers, we can make some real progress. But in the meantime, the statute is there and it is capable of being used. So that takes me to Kevin's Law. This is a different statute, primarily aimed at mental illness. However, Kevin's Law is unique in that substance abuse treatment can also be ordered as well. So Kevin's Law was originally passed in 2004, and it did not work either until it was updated in 2018. The idea was you would authorize a court to order assisted outpatient treatment for mental illness instead of hospitalization for people who fail to comply with prescribed treatment. So we have a high percentage of people with substance abuse disorders who also have a serious mental illness. We all know that now. So even though Kevin's Law is primarily aimed at treating mental illness, it is a vehicle to get to treatment of substance use disorders as well for persons who have a co-problem. So it's not a difficult process. You scale form PCM 201, it's available on the scale website. You just, when I say petition for AOT only, traditionally people have filed petitions for commitment, which involves hospitalization, picking people up and hospitalizing pending a court hearing. A petition for AOT only has no hospitalization. You just check the boxes that request outpatient treatment, and the person is not picked up ahead of the hearing. So you file the petition with the probate court. You don't need to provide any medical documentation ahead of time. You don't need any of those so-called certs. And the court will go ahead and schedule a hearing in 28 days. But that is when you have to get busy. First, you need to secure a report from a psychiatrist that the individual does require treatment under the mental health code. And if the person refuses to be examined, you can go back to the probate court and get a transport order, and the police will transport the individual to a crisis center for examination. And at the hearing, this is an important part, and this is still a weakness in the law because it requires a psychiatrist to personally examine the individual to testify. Now, in lieu of that, if the psychiatrist signs the petition, then the psychologist or a physician who has personally examined the individual can testify. Or in a rather unusual situation, the individual could waive testimony if there's a clinical certificate. The problem here is psychiatrists are fairly scarce, and we're having trouble with getting AOT cases in front of the courts because of the shortage of psychiatrists. we are advocating expanding the definition of who can testify to basically include any qualified mental health professional, which would include a psychiatrist, a psychologist, a psychiatric nurse practitioner, a physician assistant with psychiatric training, and so forth. If the court finds that the person does require treatment under the mental health code, then the court can order the individual to receive outpatient treatment for up to 180 days. And this is done through the community mental health services provider or some other entity designated by Michigan Department of Health and Human Services. And here's the important part. This is what the AOT order can provide. And it has the usual case management services and medication, blood and urine analysis tests to determine compliance with or effectiveness of prescribed medications, individual group therapy, educational vocational training, supervised living, assertive community treatment team services, and alcohol or substance use disorder treatment, or both, or alcohol and substance use disorder testing, or both. So this is really the way to kind of skip past that Substance Abuse Act and secure substance abuse treatment for persons who also have mental illness by doing it through Kevin's Law. That's a route that I don't think has been explored very often so far. We're still trying to get AOT moving and used more and more across the state. We have more counties which are getting on board with this, but change is slow. So the actual order itself has to be supervised by a psychiatrist. I'm not sure that's necessarily required either, but that is what the law provides. And once the court orders a plan, it has to be completed within 30 days after entry of the court's order for AOT, and then that plan has to be filed with the probate court. That is so that the court can determine whether or not the person is compliant with that, which is important. If you're non-compliant with the court order, then the supervising agency has to notify the court immediately. And the court can order the individual taken to a pre-admission screening unit or be hospitalized for up to 10 days. And I can tell you that where this is in place, people who become non-compliant quickly become compliant when they're told that they're going to have to go to court and the judge is going to put them in the hospital, because people with mental illness don't like hospitals much more than they like jails. So that process is working pretty good. So in terms of the guardianship process, the first thing is, so how do you get a guardian? Well, first of all, you have to meet the standard for appointment of a guardian. And that is, you have an adult and they lack sufficient understanding or capacity to make or communicate informed decisions because of mental illness. Now, there are other causes too of mental illness and substance abuse as well, frankly. And if you are in that situation, then the court can appoint a guardian. But as Laura pointed out, if there's a designation ahead of time of who you want to have serve as your guardian, the court is required to appoint that person as the guardian unless they're unsuitable, which hopefully would not be the case. And in order to prove somebody's a guardian, you have to prove that by clear and convincing evidence. It's the highest standard in the civil justice system. And the adult has the right to an attorney, an independent medical evaluation, and a trial by jury. A hearing is usually held on a temporary guardian the same day or the day after filing the petition, and a full hearing generally occurs within 6 weeks. And what is important is with the change in the law in 2018, guardians are automatically given the power to consent to mental health care except for inpatient hospitalization. But even then, if you're standing in front of the judge and you're asking the judge to appoint a guardian because your son has a mental illness, you can ask for authority to consent to inpatient hospitalization, and the court can add that to your letters of authority. So it's not a default, you actually have to ask for it. But if you ask for it, you're probably going to get it. So what does that mean? Well, the guardian can basically consent to any kind of mental health care. And in terms of inpatient hospitalization, that's done by the guardian with probate authority consenting to formal voluntary admission. And then if the individual objects or refuses mental health care, you proceed under the mental health code, but the individual has to stay in a hospital pending the hearing. Now, the area which is probably the easiest to use for parents with children who are neglecting their children is guardianship. And we have basically two kinds of guardianship. There's what they call full guardianship or regular guardianship or permanent guardianship. It's actually none of those things. It's just guardianship. And for that particular type of guardianship, the other guardianship is limited guardianship, but for the regular guardianship, you can become the guardian for your grandchildren, for example, if your child has left her children with you without providing you with a power of attorney to take care of the child. If she leaves her children with you with a power of attorney, then you cannot become the guardian. The power of attorney would end that. But the real problem with this particular part of the law is if you become the guardian for your grandchildren and your daughter disappears for 5 or 6 or 7 years and becomes bonded to you, it's very difficult to keep the guardianship in place. It's easy to terminate. And that's I don't have time to get into it in great detail, but it is this can be a problem because the guardianship is hard to keep in place. On the other hand, a limited guardianship is a different thing altogether. First of all, the parent has to agree to limited guardianship, but the parent also agrees to a limited guardianship placement plan, which is approved by the court and can continue the guardianship for failure to follow through with treatment. For example, the limited guardianship plan might say, the guardianship will continue until I can provide a drug-free household. Well, until the parent can do that, the guardianship continues. Or it can provide that the person has to cooperate with the substance abuse assessment and follow the recommendation of the assessment. Any number of things, any number of conditions. And these conditions, until they are met, to terminate the guardianship will remain in place. So my suggestion is if you have a situation where there is trouble brewing and it appears that you might have to take over the parenting duties, the best way to do it is to get a limited guardianship, because now you have some independent authority to keep the guardianship in place in the event the parent is not following through with treatment. So that is all for my presentation today.
Thank you so much, Judge Mack. Really appreciate all that information. I was like taking a bunch of notes, and I'm really glad to know that this is recorded and is going to be on our YouTube channel. And I'm going to probably have some questions for you about this like later, maybe not tonight.
Well, did I go over my time limit?
I don't think so.
Okay.
But we're going to go hear from each of the presenters first and then do the question and answer, because my concern is that if we do Q&A beforehand, the Q&A might eat up the speaker's time. So so thanks so much. And so Jodi Switalski, you're up. Looking forward to hearing from you.
All right, so I do not have a PowerPoint, and I will just tell you, I am going to talk about expungements, but the expungement laws in application are a complete nightmare if you really want to know the truth. Not that the law is poorly written, it zigs and zags, and it really does require a lot of attention and almost like mapping to make sure what can happen and how you can do that. If you all will oblige me though, I want to springboard off of what Judge Mack, actually both Judge Macks have been saying, because I have a lot of cases around the state where I'm representing. I have this tremendous pleasure of having this background, and now I'm representing individuals who are in recovery or are in full-blown substance use disorder, opioid use disorder, are under the treatment of medications for opioid use disorder, which is formerly known as MATS now. And it's not as easy, or at least in these experiences with some very well-known members of the judiciary, to which I was a member as well, are not giving in on the guardianships. And some of the big issues that we're seeing there is just an immediate transition from a limited guardianship to a full guardianship outside of the functions of the statutes. And then you develop things like what we call established custodial environments and parental presumptions. And we are in battles all over the state. But we're winning and we're starting to, really press forward in these endeavors. And so, one of the things that I'm going to take advantage of right now, and poor Lauren, she's like, just never know where Jodi's going to go. And but I want to be very clear, there are remedies out there. There are third-party custodial rights out there where even if you don't have standing by virtue of different types of guardianship situations, and I'll let the Max, if there are questions on that, talk about that. There's some case law which we're sliding in to sort of when a child has been placed with a grandparent, as is often the situation, for years, okay? And the parent comes back and they're in long-term recovery. We know that that child is bonded with that grandparent. And, there's something to be said for that. But the law really says, no, the parent gets the child back. And so, we can slide some case law in there to really create a best interest approach for that child so they continue to have contact and some sort of what I like to refer to as permanency in that. And I know that I'm all over the place here, and before I go into expungement, I just really want to talk to you all about methadone. Because within the context of all of these family law cases and custodial cases and fighting both limited guardianships with, placement plans and full guardianships or guardianships as Judge Milton Mack referred to, and they're the gurus on probate for sure. We have this overriding prejudice in our state. And I don't say that because I've had one or two cases. I say that because I'm probably at the 15, 16, 17 cases all over the state where the judge is not willing to give the child back to the parents who are in sustained long-term recovery because of their use of legally prescribed medications for opioid use disorder, i.e. methadone. I've never once seen it with Suboxone. And so in this, there are remedies that I want the courts and the jurists to consider. And if you're in that situation, I want you to think about this because I want you to tell your lawyer. You have to analogize because, again, we're having success with this. You have to analogize the use of methadone along the same lines as our medical marijuana statute. And in that, we have specific language that says, and I'm going to paraphrase here a little bit, that a parent shall not be denied custody of or visitation with their child for conduct that's permitted under that Medical Marijuana Act. This is where you have enumerated, disabilities, you have a legal card, it's legally prescribed. Think about this. It's the exact same fact pattern with methadone. You have a legal disability. It's a disease state, right? That is recognized. You're under the treatment of a physician. So the parallels are, it's very rare in the law where it's exact. And the only time you can hold that use against a parent is when the behavior creates an unreasonable danger to the minor child that can be clearly articulated and substantiated. So again, there is bias, significant bias out there, and use of this stigma for methadone and those individuals that are achieving their recovery through methadone. And I'm sure you guys have had speeches on medication assisted treatments and stuff. And so I just want to piggyback on that. And I can't tell you how many cases in probate court, sort of collateral to divorces, COVID's impact, substance use, mental health rates are skyrocketing. Please get this information from the judges, Mac, as I like to call them, because, and again, Judge Laura Mack says that it's dry information, but this is so critically important to prepare ahead of time. It makes the back end fight, that we're out there doing now, much, much, much easier. Okay. And so again, we could do a whole session on this for sure. But Lauren, Mr. Show asked me to talk a little bit more about expungements. Yikes. It's so good. You know, we're at the age of criminal justice reform. We are at the age where we're trying to balance these social inequities that have occurred. And so right now I actually have about 50, not quite 50, pro bono expungement cases. I went out and I found agencies, and they're sponsoring these expungements for individuals that are low income, that can't afford it, because the new expungement statutes, clean slate legislation, as it's often called, really took place April 11th. It was a Sunday, and so it took place April 12th. And we were ready to rock and roll and file. So all the different nuances, I couldn't even begin to tell you. It is problematic. I'm going to burn Judge Milton Mack's ear about doing memorandums of understandings in jurisdictions so that we can have, I've got clients with 15, 16, 17 offenses, all in proximate periods of time, with courts all over the state. And so, you know, there's got to be a way to make this more efficient. But for you all, it's up to 3 felonies now. So we can finally get felonies off the record. What does that mean for these individuals? It breaks down barriers for employment. They can vote. They can vote, among other things as well, not to mention just the self-esteem issues that will bring to them. They can have as many misdemeanors as possible expunged, with a couple of exceptions. You can only have 2 assaultive crimes expunged, and little caveats there as well. The felony convictions have certain parameters with regard to the convictions. If it's a felony over 10 years, there's obviously certain felony convictions that cannot be expunged. The more serious felonies that one would consider, of course, anything that's punishable by life, any criminal sexual conduct offense, you know, a sexual offense against another, if you have sexually abusive material, child abuse, a lot of different things like that. There was a case out of Judge Cleland's federal court brought forth with the ACLU that for individuals that have a criminal sexual conduct 4th degree, that's the lowest tier of criminal sexual conducts before certain timelines, we can get those expunged, and we're moving forward with those. Those are oftentimes like the 16-year-old that was, you know, engaging in sexual acts with a 15-year-old when they were in high school. And, you know, and so there's a lot of little caveats there that really defeat the stigma. There's also situations called one bad night. So if you had a string of offenses, as we often see with individuals who suffer from substance use disorder and mental health issues, because I always say substance abuse and mental health are not in silos, they go hand in hand, don't they? And so we can package those to try to get capitalize. I call it being opportunistic on the expungement statutes. If say they have 5 felonies and a number of them occurred within a 24-hour period, we can kind of package those into one. And we're going to try that very, very soon. Like I said, I have filed a ton of these so far. And as of yet, I haven't made it into the courtroom because some of the requirements are that you have to get your fingerprints, you have to get certified copies of convictions. And that's where the delay is happening. The courts are just not prepared for the influx of this right now. And they're also charging fees, which that's fine. They're entitled to do that through their local administrative orders and things, but individuals can't always afford the mass of fees, the contacts, the time to get those certified copies of convictions back. And then of course, pay the filing fee for these expungement programs. And so, you know, we're working really hard to break down those barriers. If you're in Wayne County, they have, you know, County Executive Duggan has an excellent clean slate program that he put together for the entire county. And so I just want to encourage you to really look at those options. There's different options as well. for marijuana. We don't yet have an operating while intoxicated, though there is pending legislation on this. And I want to look at my cheat sheet here. If you can do it yourself, if you go to the State Court Administrator's Office website, if you go to the Michigan Supreme Court website, they have toolkits available for you to do this and to start gathering the information. The Michigan Attorney General has checklists and such as well. I will tell you, though, that in certain circumstances, the prosecuting attorney always gets to object. They always get to chime in. And so we're going to see differences, and we are seeing differences politically in different regions around the state. So that's going to be interesting. You can't appeal for 3 years after you've been denied. So we're being very, very cautious in our presentation right now until we can challenge these. One of the biggest things as it relates to substance use disorder and mental health issues is not only do you have to have a clean record, but you have to be giving back. A lot of the prosecutors, a lot of the judges, even before the clean slate legislation went into effect, folks, that individual has to be doing something. Letters of recommendation help, community service work help. Even if you're volunteering at your local group program like AA, NA, different things like that, we can color all of those things to really show that you're contributing to society now and that you deserve this clean slate. So I'm going to kind of reserve any more dialogue for a question and answer session. Again, there are so many different ways to go about this clean slate legislation and to get these expungements. The first thing that you need to do, I just want to be clear, if you want to tackle this yourself, is get online. There's something called iChat. And you can get your criminal history. It's $10 to run it online. And you can get it. You can get on the court's website through the circuit clerk's offices, through the district courts where your conviction, where you were on probation or where you were sentenced for those. Ask them for a certified copy of your conviction. They will send all of that to you after you pay the fee. And then you simply file the document and we're going to get these docketed. So I would love to come back and tell you about the successes, about the roadblocks that we're experiencing. We're experiencing them already. But again, especially if you have individuals that are low income, we do have resources available to help and assist people with that. And I'd be happy to send that out to everyone as well. So Lauren, I know that you probably wanted more of that tick, 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 but it is just really very, very hard because of all of the nuances associated with the new expungement laws. And I can't recommend you speaking to a legal professional enough to help you wade through all of that.
Thank you very much, Jodi. I appreciate that. That was a lot of information, and it's more confusing than I realized. Apparently.
It's very confusing. So,
and I'm going to break my own rule just for 1 second before we move on to Jamie and ask you one question, and that is timing. So, what are the timing requirements? Like, how long after the conviction are you able to seek expungement?
I wish that was easy too. It depends upon the aggregate of your offenses. For example, if it's just misdemeanors, then we can go 3 years after you're released from probation or parole. If it is a combination of certain felonies and misdemeanors, then we're probably looking at 5 years. Other felony offenses and aggregate felony offenses are 7 years. And so, one thing, so it really just depends upon what's on your criminal history. And that again is part of the zig and the zag. It's just not easy to just look at it and move forward with that. I should also mention that effective in 2023, they are going to have automatic expungements for certain offenses. And that's interesting as well. One, they don't know if it's actually going to take place because they're trying to put the infrastructure in place right now, and they've given themselves an out to extend that timeline statutorily or legislatively, I should say. And so we're keeping a really close eye on that. But again, that's not until 2023. You know, we have to look at these legislative ebb and flow. There has been some pushback on this expungement legislation. And so I know that's why we're really trying to get as many people into the court system as fast as possible to take advantage of breaking down these barriers for individuals who, you know, who have committed criminal offenses and are in sustained long-term recovery, you know, are managing that recovery from either substance abuse or mental health issues before there are changes to that legislation. And with these expungements, in certain circumstances, Lauren, they go actually into sort of a non-public file. The automatic expungements that happen in 2023 are going to be going into a non-public type of file. So they still can be used against you at this point if you commit another criminal offense. So it's not a complete expungement per se.
Okay, woo. Thank you very much. I'm going to move on. I think there'll probably be lots of questions for you. But let me move on now to Jaime White. And Jaime, you want to go ahead and share your presentation with us?
Absolutely. Let me go ahead and get it up. That was a lot of really exciting information. I'm going to switch gears a little bit. Let's see. Oh, 1 second, I have to move this out of the way. Okay, thank you. Sorry about that. I'm going to shift gears a little bit and just talk for a few minutes about our mobile crisis co-response programs that we have at Hegira. And we have really focused over the last couple of years on partnering with law enforcement, specifically to meet the needs of people in crisis in the community and really at that first point of crisis, to attempt to link them to services in the moment, usually when they're more amenable to accept treatment, and hopefully get them on that path to recovery as soon as possible. And there we go. Not sure why it's doing that. Okay. So just a little bit about Hegira, if you're not familiar. Hegira Health is a comprehensive behavioral health care provider. We serve all of Western Wayne County. We've been around for quite some time, and we serve individuals with substance use disorders as well as mental health disorders, children, adolescents, and adults. We run Oakdale Recovery Center, and we have a few outpatient clinics that provide outpatient and IOP treatment. And then part of my role is over our COPE Crisis Services Division, which is where our co-response programs are really embedded into and dispatched from. So COPE has several different programs that are really part of our crisis services hub. And I'm just going to touch on each of these briefly. We provide mobile crisis intervention, doing all pre-admission reviews for Wayne County emergency departments, which basically means that any adults that are funded through Detroit Wayne Integrated Health Network, the community mental health funding source for Wayne County. Excuse me, I have 2 kids and a dog in the other room, and they've been quiet up until now, of course. So I apologize for the background. So we do pre-admission reviews, really assessing people in their state of crisis and moving them on into the next level of care, whether that be inpatient psychiatric hospitalization, residential SUD treatment, or some sort of outpatient treatment regimen. And we also do co-response with our select police departments throughout Western Wayne County, and we respond directly to adult foster care homes throughout Wayne County. Our mobile crisis stabilization teams are able to provide next day follow-up and work with individuals in crises for up to 28 days to really provide care coordination and follow-up. So, you know, what we have found is that a lot of times when a person is in a state of crisis, whether it is a substance use or a mental health crisis, they are, you know, like I said previously, more amenable to agree to receive some sort of treatment, but there's a lot of barriers in our system in accessing care. It can be very confusing. And, you know, it's confusing for people that have resources, and it can be even more confusing for people that may not have resources or may not have the support people in their life to help walk them through that process. And so our goal is really to get them linked up to ongoing services to prevent any future crises. We run the Crisis Stabilization Unit in Western Wayne County, which is located in Livonia, right off Schoolcraft Road by Farmington. And we are able to provide 24/7 walk-in crisis care, again, for people struggling with substance use disorders and or mental health. And we also have our Engage Rapid Response teams, which provide immediate response for SUD-driven crises, including post-overdose outreach. That's funded through the Michigan Opioid Partnership, and we're very excited. That's a newer program that we are promoting. And this is outside of COPE, just in case you've driven by and weren't quite sure what it was. Through COPE, we have been working on law enforcement partnerships for the past 2 years. We do mobile crisis co-response. I'll talk a little bit more about what these entail. Mobile crisis co-response with Northville Township, Inkster, Plymouth, Romulus, Westland, Wayne, and the city of Northville just jumped on board. And then we're working on embedding a clinician in both Livonia and Canton Police Departments. Those are the programs that have really gotten a lot of media attention over the past several months. Due to everything that's going on, I think, in the social climate and the commitment that the cities are putting forth. But again, we've been working with several other departments in Wayne County for a couple of years. This is our friend Zeke the therapy dog out of Wayne Police Department, who we love. And so just a little bit more about mobile co-response and what that entails. Co-response is really a coordinated community-based response between law enforcement and behavioral health professionals. It not only provides support for the officers, but really provides that warm handoff to mental health care and those follow-up services. So I've been saying mobile crisis team a lot, and what I mean by mobile crisis team is it's a licensed behavioral health clinician. That could be a social worker, a professional counselor, or a psychologist. In Michigan, if they're licensed, there's a lot of overlap between their duties and responsibilities and their scope of services. And also a certified peer support specialist or peer recovery coach, somebody who has lived experience and is certified by the state to provide those peer services. We utilize peers a lot throughout our programs at Hegira. And really feel like they add an invaluable layer to treatment that, you know, trained professionals really cannot, in speaking with somebody who's struggling. Excuse me. We also make sure that those staff members are trained in CIT, which stands for Crisis Intervention Team, which is a de-escalation training that is focused for police officers to learn how to better respond to individuals in crisis in the community. There we go. Okay, so just briefly, the way it works for co-response is the officer will be dispatched out to the community for a call of somebody who has some type of behavioral health issue. If the officer determines that they really can't take them into custody, they don't have enough information to petition them, the person has not committed any sort of crime, but they know that they need additional resources to get the help that they need, then they will contact our dispatch at COPE. Our mobile crisis team will then meet them at a neutral location. They'll debrief them on what has happened, and then they'll go back to the home together. And again, what that does is provides a sense of familiarity for the person in crisis because they've already had contact with the officer. The officers have already deemed that the scene is safe for our staff. And then there's that warm handoff for the person in crisis. Once our staff's there, the first thing they do is really talk to the person that's in crisis. They find out what's going on, what needs do they have, are they already linked up with somebody in the environment, is there another support person that they can call, and then they do a full crisis assessment. So the result of that crisis assessment it can really run the gamut. They could say, you know what, we really need to get you to see a psychiatrist immediately and recommend that they go to a crisis center. Or it could be, you know, really hooking them up with resources and getting them scheduled to see their therapist the next day. So it's very individualized based on what's going on. The embedded clinician programs, again, at Livonia and Canton are working a little bit differently. So Livonia and Canton have said, you know what, we want somebody who is part of this department. We want somebody who's building relationships with the officers and who is available to us to respond to all citizens, you know, in our city or in our township. And so it's really more of a collaborative partnership, not only to select the staff that are going to be there, but also in developing policy and protocol and how all of that is going to roll out. I put proposed programs up there because we have not yet started providing services in those jurisdictions. We are still in the planning and implementation process, but that person will be available to co-respond in real time with officers, or will be dispatched to go out once the officer secures the scene. And then they can also provide crisis intervention during that initial call, as well as those crisis stabilization services. So, you know, our hope is that these clinicians are really, you know, become part of that department and part of that community, and, you know, get to know the residents, get to know the people in need in that community, and are able to be a really good resource. And that's all I have. This is my contact information, and I'm happy to share my slides with Lauren as well, if anybody wants them afterwards.
Thank you so much, Jamie. I really appreciate that information. I think the program that you guys are just starting with the Livonia PD, and which was the other one? Livonia and which one?
Canton.
Canton, where you actually have someone embedded with the police departments, is really exciting.
Yes, very exciting. Thank you.
Yeah. All right. So I'd like to open the floor up to questions now, and you can either sort of jump in. I'm going to change my view here so I can see the gallery of people. Or if you want to put it in the chat, that's fine as well. I did see one question that was already in the chat that I'll just put out there. I think this is probably for Jodi, although maybe someone else will. I kind of leave it up to the participants, but I think this looks aimed at Jodi. Are MIPs for marijuana 17-year-old from 2017 eligible for expungement? And would that affect what insurance companies charge for their insurance? The person was not a driver for either of two charges.
That would be legal advice, and I'm not going to go ahead and look at that. Is that the only thing? I mean, if you want to call me on the side, I'm happy to do that, but I would want to ask some more questions about that. There are some juvenile adjudications and possibilities there. We'd have to look at the disposition date. You said 2017, correct?
Yep.
It should be eligible to go, as you know. You said it was possession of marijuana.
It just says MIPs for marijuana, minor in possession. Yeah, for marijuana,
yes.
17-year-old.
There was no deferral already on that.
This is all I see. Lynn?
I have no idea.
Okay, yeah. So what I'm going to do is, because I didn't do slides, and I always do slides. I'm going to go ahead. I'm just going to put my email address into the chat, so that if you have some questions like that, feel free to email it to me, and then I can ask questions back and give you a little bit more a little bit better feedback. I hate to say something with, again, there's a lot to this, like that deferral and delayed sentence statute under MIP, the 436 statute. And so, that impacts our ability to get things expunged and how we go about doing that as well. There are juvenile expungements. There's also some really fantastic checklists that are available out there that I'm happy to share also.
Thanks so
Thank
much, Jodi. I see Lynn Smith has her hand up. Lynn,
Hello.
there we go.
Hello.
Hi.
My name is Lynn Smith. My question is directed towards the young lady from Hegira. And the question is, I have clients. I work for Naomi's Nest in Elmhurst. I have clients because I deal with mental health and substance abuse, co-occurring disorders. And I had a few clients I had to bring out to Livonia. But my question is, do you guys not have something at Team Wellness that you just opened up for crisis for mental health? And that's one question. The second question is, I have a lot of people that's out of county. They're from Wayne, but they like from out of county because they might have caught a case somewhere and then they just sent them over to us with mental health where I can't get them into like Team Wellness or the Guidance Center or something in Detroit. So I was wondering, could I bring them people, the ladies and men, over to COPE to get them stabilized, because I have been using Team Wellness Stabilization Center. And I was wondering, do you guys stabilize people that's out of county with insurance?
Yes. So first question is, Team Wellness did open a crisis stabilization unit about 6 months ago in Detroit near Eastern Market. That is not part of Hegira. But we coordinate with them as needed. Yes, there are things called COFR agreements between the counties. And so if somebody is out of county or has out of county Medicaid, because that's often the case, then we will work with Detroit Wayne Integrated Health Network to ensure that those COFR agreements are put in place and that that gets worked out on the county level and their services are covered. So yes, Team Wellness also has a shelter, which is used for more longer term placement. So if you were to bring them to COPE, we would do the full crisis assessment and then determine what level of care is needed afterwards. And we could provide those crisis stabilization services for those 28 days as discussed as well. So they wouldn't necessarily stay with us. Those services are provided in the community.
Okay, I just needed to know about the stabilization. Yep. Because they'll come back to us for their treatment. Absolutely. But their mental health, because they're designated to us through the courts. But I'm just having trouble sometimes because I do case management and counseling. And I have trouble sometimes getting them in to get stabilized, and I end up taking them to Receiving Hospital to get them stabilized.
Yes, yes, you can bring them to COPE as well.
Okay, thank you.
You're
yes,
welcome.
thank you. I also see a question in the chat right now. If a person received Holmes Youthful Trainee or MCL 333-7411, do they need to apply for expungement?
Again, it would depend upon the circumstance with that. For example, with the marijuana statute or the marijuana question, if with regard to any drug offense, if it's not now legal, then you're probably not going to get expunged. There's just any number of different nuances with the HIDA stuff. Let me look at my little cheat sheet here. This is what I do with all of my cases myself, and I will come back to that. Okay.
Yeah. I
hesitate to, again, the broad picture of this, it's not as simple as just saying, they got a 7411 for a drug charge. You know, there are other conditions, exactly what the offense was, what the possible penalty was, did they successfully complete probation? You know, there's a lot of different things like that that go into the analysis also. So I can't just sit here and fire off yes, no, to these questions. It's just not that simple.
Unfortunately, that's the nature
I
of the
wish
law.
I could, you know, so
It's the nature of the law, right, Jodi?
it is.
So Neil, I see your hand up, but LaShawn Battle had her hand up first. So let me ask LaShawn first, and then Neil we'll get to you next.
Thank you.
What are the qualifications for being an angel?
Jeff, are you with us? Jeff Jones, our angel coordinator. So I don't know off the top of my head. You have to be in recovery for, I think, 1 year, I think. And that's about the only, you know, limitation on your being able to be an angel.
I think you have to take the CCAR training, don't you?
Yeah,
Or the McBath.
there's training involved with that.
Yeah, for
Yeah.
sure you have to undergo training ultimately.
Right.
But initially to qualify to be able to do the training, I think the only requirement is that you have been in recovery for 1 year.
It's just a year. Okay.
Yeah. It used to be 2, but I believe they changed it to 1.
Jeff, if you're out there, you could just unmute. You'll have to unmute.
And you don't even have to be a substance use person. They will take
Right.
anyone.
No,
For
I
angel.
am a person in long-term recovery. I actually have 26 years clean. I was just wondering what was the qualifications and how do I get in touch with you all? Is there a number or something?
So LaShawn, go on our website and just go on Families Against Narcotics, right? Google that. And then you'll see programs, sort of a tab at the top. If you hit programs, the drop down will be Hope Not Handcuffs. Click on that, and then you kind of scroll down and you'll see a big sort of side part of it that says Be an Angel. And you just kind of click on that and you follow through it.
Thank you.
You're welcome. All right, Neil, you were next.
I have 2 questions for 2 different people. Jamie, is COPE open 24/7?
That's an easy one. Yes.
Can anybody walk in there? I mean,
Anybody can walk in there. Anybody can walk in there regardless of ability to pay. We have a psychiatrist there 24/7. We have mental health professionals there 24/7. We have hot meals, hot shower.
no, I live
And
in
we-
Livonia, and that's wonderful news. I have a son who has some issues, but
Yes.
why isn't that in the Livonia Observer? I mean, that should be, you know, that should be front page to me, or at least,
Well, if you
I mean,
make it happen,
don't
I'll
hear
write
anything.
something up.
I don't hear anything about any of this in their local papers, and that really irritates the heck out of me. Thank you very much for that question. Second question is for Lauren. Lauren, you had mentioned that Hope Not Handcuffs has helped or assisted 5,000 people. The number's impressive, but are there metrics with that? I mean, okay, if 5,000 people went to Hope Not Handcuffs, where are we now? I mean, are those 5,000 people, is there a follow-up with that? You know, what percentage of those people have relapsed or on the positive side, have made it through?
Well,
I need a metric.
that's a great question. I do not have those metrics at my fingertip. I can tell you that while we helped over 5,000 people, and I want to say it's close to 5,500 now, access treatment, you know, we are not the ones who are providing the treatment, right? We are basically helping them access treatment that's available to them based on their insurance situation and that type of thing. So they have, you know, the same, you know, type of statistics of being successful as anyone would going into treatment. So, you know, are they all successul? You know, once we help them access it? Of course, the answer is no. We do have follow-up with them, though. There's a group of like angels, I think, and people, actually not angels, people who've been through the program, been successful in recovery, and we've worked to build sort of an alumni group called Hope Heroes to help them provide support to each other and to reach out to people who are going through the program. So we've made that kind of extra effort that happens after that initial accessing treatment. But again, in terms of how many, like the numbers of how many have sustained recovery, I don't have that, but I can guarantee it's not 5,500.
Right, right. And you know, that's, you need something to balance it against and with for, you know, and how well is it working?
Here, come here.
Also, I want to say thanks to the guest speakers. You guys were great. Thank you so much. You gave us a whole bunch of information. Thank goodness it's going to be on the webpage or on the Facebook page, because I couldn't write fast enough.
That's how I feel about it too. I'm glad it's going to be on the YouTube. Don't forget our YouTube channel, right? Okay, I see someone who's had their hand up and they've mentioned it in the chat as well, but it's ORC-. Okay, yes.
Can you hear us?
We can.
Okay, go ahead. It took us a minute to get that together. All right.
Hello. My name is Elton Walker. I called a case over about 44 years ago. And it was expunged from my record, but why is it still keep coming up? Can she tell me something about that?
So I think that was aimed at Jodi, but it sounds like legal advice. It sounds like it's probably more specific than you'd feel comfortable answering at this point, but I'll go ahead, Jodi.
Well, and I couldn't hear everything that he was saying. If it was, it's showing up on your record after 46 years.
Yes, I didn't go to jail, prison or nothing for it, but it's still on my record, I think.
From the state of Michigan?
Yes, and I had it expunged.
Well, if you had it expunged, then it shouldn't be on your public record. And that's one thing I was starting to type about the HIDA question, is that HIDA is a deferred sentence status that you don't really have a conviction that can be expunged, and the case just gets held into a non-public file, which, remember, these expungements are convictions that just, sort of get wiped clean from your public record, but many of them are placed into a non-public record that can be used against you later. So the idea and the use of the word expungement is a little bit deceptive. And so I don't have the foggiest idea why something should still be showing up after 46 years, unless it was the severity of the offense, of which I'm not asking and don't expect you to elicit any of that. Again, if we ran your iChat, which is, the Internet Criminal History Access Tool, I think is the acronym for that. You can just Google iChat and put your information in. I'd have to take a look at it. You can always petition the Michigan State Police, about this. If you truly had it expunged, then sometimes there are clerical errors that can be very easily corrected on the dispositions. Keep in mind, these poor clerks, if they hit one little button wrong, then it changes the whole disposition. So I don't have a good explanation as to why that should be on there without knowing more.
I understand what you're saying, but they sent me something while I was in prison for something else, that it was a sponge. But you can go to somebody else. I understand what you're saying.
Okay, thank you. And thanks, Jodi, for that response. Also, I want to note in the chat that Jeff Jones put the link for the Hope Not Handcuffs webpage on the Families Against Narcotics site for people who are interested in exploring more what's required to be an angel. And also, Christine Jones took from the website the Hope Not Handcuffs angel qualifications. So if you're interested in that, you can see that is in the chat right now as we speak. All right, it is 8:04, so we've gone a little bit beyond our time. Maybe we'll take one more question if anybody has one, and otherwise we'll wrap up. I heard someone say aye.
You heard me say thank you.
Oh, okay, great. Well, you're welcome. And thanks so much to our speakers. All right, so I think we're going to wrap up. I am going to, though, one more time share my screen, because there did seem like there were a lot of questions about how we can get access to PowerPoint slides and that type of thing. So I want to put this up on the site here so you guys can see. And somehow I ended up at the very beginning slide, which is not where I want to be. All right, so just again, you see on this slide, there is our email address. So I did see someone wrote in the chat that they were interested in getting a copy of slides sent to them. If you have that, or if you want to reach out to us about other questions relating to this forum or basically anything else regarding the work that we do, our email address is right there. Also, our Facebook page I mentioned before, our next public forum is going to be included there as an event, and our support groups are also included there as events when they meet. So you might want to like that page. And since I know that many of us, including me, will be wanting to watch this presentation again, it's going to be on our YouTube channel, NW Wayne Fan. So that concludes our meeting for today. And so I just want to say thank you so much to our speakers. You guys were amazing with the amount of information that you shared with us. Hopefully I'm going to be reaching out to those of you who had PowerPoint slides and ask you to provide them to us, because I think that there are going to be many people who will want to access those. So thanks everybody. And I think, oh, in the chat, Jodi said she'll send links for some of the legal access information related to expungements. Good. All right, thanks everybody.
Thank you. Have a good night.
Thank you.
Bye.
Hi, Dora.
Hi, Brandon. How are you?
I'm doing great. How are you?
Good. Good to see you.
You too. It's a great meeting tonight.
It was good. A lot of great information.
Appreciate your footwork doing this job and everything.
No problem. We're happy to do
See you
it.
guys soon. I hope to see you guys soon. So,
Well, we hope so too. Maybe we could do something this summer. Who knows?
yeah, we'll see.
All right.
Good things to look forward to. It's good seeing you.
Exactly. You take care. Okay. We'll see you next month.
Okay. Bye, Dora.
Bye.
Hey boss, how you doing?
Good. How are you?
Busy.
Are ya?
Yep.
What's going on?
Just doing stuff for the government, nothing else.
Ah, good deal. Good, good. I had I probably wait to share another time, but it's just something I should probably just share with you and I. Anyway, I was wondering, did you have any luck last week with IHA?
Oh, that was last week was our site visit.
Oh,
We got
okay.
we had a visiting professor come in and grilled all of us. We didn't do any regular visits. I need to stop. I'm not sure. There might be something scheduled next week. I'm not sure. It's normally the third Wednesday, but everything in April was taken up by that site visit.
Oh my goodness. Wow. Yeah. Wow, that's crazy. Hey, did you get your doc in?
Let's not talk about that. That didn't go too well. They didn't show up.
Oh no.
Yeah.
Oh, that's a bummer. Well, you can always reach out to Jaime. I'm sure he'd lend you a hand if you needed it.
Well, I don't need a hand. I need my dock put in. It's all set up. They just didn't
Is the
show
dock
up.
there?
Yeah, it's set up on the grass.
Oh, gotcha. That's a bummer.
So.
All right. Tell Kathy I said hi.
I will. See you soon.
Keep me posted, okay?
I will.
Okay.
Bye-bye.
Thanks. Bye.